Welcome, welcome. We have 4 panelists. We can call them sports lawyers, but we'll see whether they really think they are sports lawyers. Chuck, what is it you do relating to sports?
Very good question, Arthur. I'm still trying to figure that out. So I asked Arthur, what is sports law and how does one create a curriculum around that subject? I'm an M&A private equity lawyer by training. I was an athlete in college, always a sports fan. I grew up at a couple of big law firms as an M&A and private equity guy. I had the opportunity to buy the Dolphins for Steve Ross, their current owner, about a decade ago. And then I bought 2 or 3 other teams for current club owners. And I said, wow, this is really fun. This is sort of marrying a passion with a profession. And if I could find a different firm where they really wanted to build this practice, which is now a huge practice, not just on the M&A side, but on stadium finance, on media deals, on sponsorship deals, on litigation, on collective bargaining, that would be a lot of fun. So I was approaching a decade birthday, and I said, now may be time to make the jump and time the market well, more luck than skill. And so I buy and sell teams and other sports properties for a living.
You're still a deal maker.
I'm a deal maker.
A deal maker.
Or a deal breaker.
All right. Whatever floats your boat. Now, Greg, you come out of the Harvard Law School in '77. You had me for copyright?
I did.
3rd year?
I'm still waiting to see that blue book.
See, they don't even know what a blue book is.
Really? You don't use them anymore?
How do you get involved in sports?
In my case, it was totally fortuitous. I went to Covington in the fall of '77 and was assigned on my first day in the office to a partner by the name of Paul Tagliabue. And I figured out pretty early that Paul was terrific at delegating work that was not sports related. But he husbanded the work that was sports related, and the people who worked for him, the associates who worked for him, as young lawyers, carried his bags, and they got to interact with people in the sports community. But I opted for the other route. I did no sports work for him at all, ever. I did establish a good relationship with him. I went on to pursue a varied litigation career. And not long after he became commissioner, the senior people at Covington who were responsible for the NFL work, who had inherited it from him, went in different directions. One was Jeff Pash, who left to become the general counsel of the NHL and who's now the general counsel of the NFL. And I had this relationship with the commissioner, and I stepped up and said, I'm happy to assume the role, and he was happy to have me. And so it was not by design, it was totally by fortuity.
So in the vernacular, Covington is outside counsel.
It is.
For the league.
The league, among others.
And what do you like about that?
Probably the best thing from my standpoint is that my kids all think I'm a pretty cool guy because the things I work on are in the newspaper.
Actually, I think what he likes is he likes to represent monopolists.
Aha. I sense a certain tension between you two.
It's a friendly tension, but there's a tension nonetheless.
So what would you say 50, 80, 100% of your work is sports or NFL?
More than 90% of my work for paying clients is sports or NFL.
Chris, how about you? You're not like the other 3 guys.
No, I am really not a sports
You're
lawyer.
different.
Yeah, I'm a personal injury lawyer, and I'm questioning why you invited me to this. But
We
I'll
needed
talk.
an ambulance chase.
Yeah, you got me. So I do personal injury cases, and often the cases turn out to be pretty big cases, handling mostly pharmaceutical litigation. I got involved in, I guess, what you call sports law, but to me is just personal injury litigation. When a group of players were sent to me complaining about problems that they thought was associated with concussions. And from that, we worked up the case, investigated it, began filing cases against the NFL, as Greg knows, and have ultimately settled, I was appointed co-lead counsel, and we ultimately settled the concussion litigation.
You know, why'd they go to you? I mean, you're big in pharmaceuticals, as you said, Vioxx and Zyprexa and all that stuff.
I think they were looking, or the lawyer who was helping them was looking for a trial lawyer or somebody who would take on a case like this, a risky case, against a well-funded and pretty powerful defendant. So I guess luckily, my name came up and I got the call.
Under the heading stupid.
Probably. They
I
said
mean,
this-
those are two pretty,
They might have gone to a bunch of other people, and I might have been the last one on the list. I mean, that's likely.
very, very high
Yeah,
risk.
this idiot he'll file a case and go against the NFL when nobody's ever done very well against the NFL. So, but yeah, so that's how. I mean, I definitely wouldn't call myself a sports law person simply because this is really my one case. I was approached about getting involved in the NHL stuff, and now it's spread to the NCAA. And you know, frankly, I won't go into it unless you want to talk about that. But I wasn't very interested in those cases, so I'll probably go back to picking on pharmaceutical companies.
I'm happy to hear that.
Well, that's interesting. Why did you make that decision? Didn't you get a kick out of the fact that your name was in the paper every time
No,
Judge Brody did anything in Philadelphia?
Yeah, that's pretty annoying. And I actually, to be honest with you, I spent way too much time dealing with that aspect of it, with the telephone calls I get, and you know, sometimes from former players, and they want to talk to you, and it requires a lot of, you know, a lot of work, a lot more work than I'm used to putting into that part of the case.
Well,
But-
normally you don't have clients. You
no,
just
I have clients. I have clients. I'll push back against that.
When you're going against Vioxx and
I know that Bill
Zyprexa.
Larac made a comment like that.
Yes, he certainly did.
He's a class action guy, and he was in those cases that was economic loss, and I'm handling, you know, personal injuries. And I do typically talk to clients, but not, you know, not by the hundreds like I've had to in this case. But you know, I guess the point I was going to make is, you know, after looking at the case, and I'm not trying to pick a fight with Greg, and you know, the case has settled in a great way. And although I know this is being recorded and will probably get me in trouble with some of my clients, the retired players, by saying this, you know, nobody has ever won a and we're going to get into this later, but nobody's ever beaten these guys on the preemption issues that are existing.
They're
in
like
case.
the tobacco industry. They never lose.
They had great defenses, and they deserve a lot of credit for trying to do the right thing by players that were having problems. So I think that's what helped, that's how the settlement came about.
Yeah. For those of you who have not followed this case with any detail, you may not realize how risky this case was. You got, well, give us the 5 biggest problems you faced.
Yeah, there's a line on my face for each big defense they had. Well, we could start with preemption. You know, these are collective bargaining agreements. Again, you know, I deal with preemption issues, but typically in the Wyeth versus Levine, the preemption issues about whether an approved drug with an approved label should be, not in this context so much. And as you know, in part of my investigating of the case, I looked at this issue and was very concerned about it. It's a big issue. And there are about, as far as I know, I mean, I knew all this data at one point, but there are 4 or 5 cases where, in fact, plaintiffs have sued the NFL for personal injuries, either related to concussions or others, and the cases have been dismissed, pretty much across the board. I think maybe there's one instance where that hasn't happened. So that's incredibly risky. And in the context of an MDL, which is when you have a lot of cases in federal court, they all get sent to one judge to be handled. You've got one judge deciding that issue, good or bad, for either side, but across the board. And you know, that motion was pending, argued, and with the judge when the settlement came about. And it stood to, if the plaintiffs didn't do well, there were some gap periods where players weren't covered by a collective bargaining agreement, although there was risk on those cases as well. But let's say those were the less risky. I mean, it stood to wipe out, you know, 80% of the cases if we lost. And then if you get past that, you have assumption of risk. I mean, you know, listen, if you ever got involved with focus groups or you looked at these issues, you know, many of these injuries are very, very sympathetic. And many of these guys, they're living on the street, some of them, which have issues that relate to football or don't relate to football for all kinds of reasons. And some of them are coming down with dementia and Alzheimer's and ALS and all kinds of things. You know, you've got still at the end of the day some highly trained athletes running into each other with their head. And, you know, as you see in boxing, you know, you've got 2 guys throwing punches at each other. So you've got that issue. And I could really just kind of keep going, but I don't know if you want the whole list. But
No, it's
Well,
extremely
the other
risky.
issue would be causation.
Causation.
I mean, that, I've always, looking at the cases from the outside, I always thought that was a big issue from the plaintiff's side, because you've got athletes who begin in football, playing football when they're 8, 9, 10 years old, and then you go through high school and then college, and, it's part of the injury is the repetitiveness, and I just think it'd be tough, you'd be trying, you'd have to try each case individually, or at least arguably.
well, did you, just assume the case where they've got a highlight reel for the guy playing college and he's knocked out on the field.
Yeah.
So are the damages really coming from his playing the NFL or from college? Or Pop Warner? Many of them started, a lot of studies that say, in those very young brains, you're at higher risk for developing problems long term. And then even getting to the science, and the last thing I'll say on it, and again, even the established science that is out there is not a slam dunk. I mean, all the talk about CT, I'm being open and honest for the purposes of this class here, but, the science on CTE is anything but well-established, okay? There are some studies that probably would have gotten to a jury, but the NFL had some pretty good studies saying suicide, depression, Alzheimer's, and all these other things are not associated with CTE, which is kind of a very new diagnosis.
As a footnote to Chris's point on the preemption motion, that was the one issue that was argued before the judge in Philadelphia. In his concussion cases, there was a subsequent case brought by Richard Dent, a class action on behalf of a group of players who alleged that the league had engaged in abuses of prescription drug medications.
I passed on that one, too.
That was a smart move, because the same preemption motion that was filed in Philadelphia in the concussion cases just a few months ago was successful in the litigation involving prescription drug medications. That case is on its way to the Ninth Circuit, but it's effectively, at this stage at least, it looks like it's effectively over.
Yeah.
How do they deal with the 3.5 years of decertification?
Now, as a proceduralist, there's also the question whether any judge could or should certify your case as a class, given the individuality of the injuries and the situations of each of the players.
Yeah,
So-
well, I mean, look, the good news there, and there are many different models that parties can use to settle a case. The class action was something, look, the NFL at the end of the day was not looking to spend a lot of money resolving a problem, however big you view it on their behalf, and then just, gin up more litigation against the NFL by new rounds of, people getting involved. So they wanted total peace. The result of being able to sell them total peace was a very rich settlement for a group of players who are seriously injured and need the compensation. So it's a good trade-off. The other fortunate thing we had is that it truly is a personal injury settlement that lends itself to class action treatment. Because there were, first of all, it's a very ascertainable class. It's about 22,000 retired players. We know who they are. You know if you played in the NFL. It's not an AmChem problem where you've got people who came home, dad took his clothes off, mom took it, did the laundry, and got some asbestos fibers, breathed them in, and you didn't know who the class members were in AmChem. We didn't have that problem on notice, so we could get to everybody. And then you had, we focused the issues that predominated in the case on very common issues. Did the NFL owe a duty? Does head-hitting lead to CTE or other injuries? So we were able to define it in a way that I think lends itself very nicely, actually, for class treatment. And then because it's a settlement class, we don't have manageability issues or the differing state law issues that you'd have to deal with in a litigation class. So.
Now, Jim,
Yes,
how'd
sir.
you get to sports law?
Because I was standing at a urinal one day, and a partner...
Everybody have a picture
At
of
Weil. We didn't look down, and the partner looked over to me and said, "Would you like to work on the Oscar Robertson basketball case?"
Do you know who Oscar Robertson is? Not everybody in this room even knows.
I see the older folks are nodding their head. That's helpful.
Doug is
The Big O, probably,
Big O, of course.
one of the great, if not the greatest player in the history of the NBA. And that was at a time when the reserve systems were still in effect, and it was a class action. Speaking about class actions, it was a class action that was filed on behalf of all the players in the NBA. The original purpose of the class was, or the lawsuit was actually to prevent the ABA and NBA from merging in the spring of 1970, because with the beginning of the ABA, the reserve system that existed in basketball began to crumble because you had two leagues actually competing for players. In the 3.5 years that the ABA was in existence prior to our seeking the injunction, average salary in the NBA had gone from something like $16,000 a year to over $60,000 a year because of competition from the NBA, from the ABA. We got the merger enjoined, and as part of that lawsuit, we also sued the NBA separately with regard to its reserve system, which involved compensation, option clauses, the draft, the whole 9 yards. And that case went on for several years. We were very close to trial, and eventually it was settled in what came to be known as the Oscar Robertson settlement, which was the first big settlement even before the free agency in baseball. We actually had accomplished free agency in basketball, which went on. And after that, through that, I ended up representing players in all of the leagues at various times, hockey, baseball,
So I assume you've
football.
dueled with Greg from time to time.
Yeah, I was a little surprised when you said that the NFL always wins, because the two times I sued the NFL, they lost both times.
I said that, don't blame him.
No, he said it. I was listening very carefully.
I'm trying to
gets
determine
different
whether
results.
Greg's face is getting redder.
No, he's fine. He wasn't around for the first one for sure, and actually
That
not the
explains
second either.
difference.
The first one was one of the things I also specialized over time was in representing failed leagues. So I represented the North American Soccer League, and then later the USFL, of sainted memory, the $3 league.
Both of which are back.
They are, that's right, in smaller forms. But we sued on behalf of the NASL versus the NFL. We sued the NFL for they sought to put in rules to prevent cross-ownership. They didn't want any of the NFL owners to own teams in, of all things, a soccer league, okay? The great thing I love about the NSL, I still have a soccer ball in my office, and the logo on it is NASL, the sport of the 80s, okay? They were off by 30, 35 years.
Yeah.
It wasn't, they eventually kind of got there with the MSL. And then
never-
the second time we sued for free agency in football with the McNeil case, and it was ultimately led to the White settlement.
I've never heard anyone say, I represent failed leagues.
There's a lot of them out there.
Yeah.
That's
A
real
lot of people have represented
specialization.
failed leagues. They often fail. It's been imperfect. When you have, monopolists like the NFL, it's very tough to compete with them.
Are you going to take that from him?
Absolutely. I was going to ask him how much he won in that suit.
Is it
involving
$1 but
USFL.
treble?
Oh, the USFL? Well, we actually came in after the trial to do the appeal because there was a finding of monopoly. And it was a $1 finding, trebled, of course, because of any trust laws. So but we were going to try to get injunctive relief as a result of that. And we came up with this great plan, basically, which neither Judge Leeser nor the Second Circuit bought, which was to require that the NFL give one of the slots on Sunday afternoon to the USFL. And it was brilliant. I mean, a brilliant idea. Nobody bought it, but it was brilliant nonetheless.
So, do you consider yourself a sports lawyer?
No, not really. I've actually,
What are you, a litigator?
I'm a trial lawyer.
You're a trial lawyer.
Yeah, there's
They
a
still
distinction.
have those things?
They do,
You
from
guys
time
are-
to time.
Almost everything you
We
guys
handle
have
them all.
said is, it was settled. It was settled.
No, McNeil wasn't settled. The NASL wasn't settled. And nor are many of the lawsuits I've lost for Exxon. They were not settled. We lost them.
So, we've got a deal maker.
But I said somewhat facetiously that there is no such thing as sports law. When you look at the money that is driving the prices of franchises in all of the major leagues, the NFL behind its television contract is obviously the king. But if you look at the accretion in each of the leagues, from the NBA to Major League Baseball, the NHL, and I'd now call Major League Soccer a major league, so the fifth league, There is a tremendous amount of revenue there, and many of the buyers of these teams are people who have had great success in other aspects of their professional careers. So in Steve Ross's case with the Dolphins, it was real estate. In many of the more recent cases, it's very successful private equity or hedge fund guys who have made a living spotting what they believe to be undervalued assets and invoking certain financial and operational measures to improve the return on these assets. These professionals, many of them have their Covingtons and their Weil Gotschalls and their other terrific grade A law firms. But when it comes to buying a sports team, thankfully they come to guys like me, because as long as they're drinking the Kool-Aid, I'll keep pouring it. They believe to buy a sports team, you need a sports lawyer. And while I say that somewhat facetiously, I happen to believe, maybe because I'm selling my own BS, that that's true.
Is that a technical term?
Not in your class. So what I believe my team has that, and our team on the stadium finance side has, that an M&A lawyer or just a project finance lawyer does not have, is relationships with each of these leagues. So if I have a very well-known hedge fund guy, private equity guy, whomever, who wants to own, I'm selling the Atlanta Hawks right now, that's public, that's not a secret, who wants to own the Atlanta Hawks, the first thing one should do is introduce him to Adam Silver or one of Adam's people so that they can sort of pre-clear him, get to know him, determine sort of early on whether he's a viable candidate for NBA team ownership, because each of these leagues, whether it's the NFL, the NBA, MLB, they essentially function as the SEC. They are the third party on every single transaction I do. So whenever I do an NFL deal, I have one of Greg's partners as the third party on that deal, buying or selling. NBA, MLS, typically Proskauer, NHL is Skadden. But what we have is the currency. So I can have a private equity person or a hedge fund guy or whomever walk into my office and say, I really love, basketball. What's for sale? I don't want to own a whole team. I want to own a piece. And we have that knowledge. We can also get them into the leagues. Importantly, there really is such a thing as sports law in the sense that each league has its own rules and regulations, and they are, this deep if they were still in written form. But they all prescribe very, very strict standards in terms of how much equity you need to own to buy an NFL team or an MLS team or an NBA team. How much debt can you put on the team? What can you secure that debt with? Can it be team assets? Can it be stadium co-assets, ticket co-assets? So there are very, very complex regulations, not unlike the 33 and 34 Act that, truth be told, you should know. I'm watching now, representing one of the Hawks bidders, a very, very prominent, well-known takeover law firm in New York, stumbling a bit on some of the things they're doing, because sort of unlike buying Kraft Foods or buying RJR Nabisco, when it comes to getting together 10 rich guys who want to own an NBA team, there are a bunch of things that you should be sure you do with respect to that group of 10 guys to prevent things from happening to that bid group during the process. And, they may not have done that in one or two cases. So I do think there's a way of doing these deals that develops, and there's a currency, and for so long as the wealthy guys out there that can afford to own these toys believe it, I'm going to keep selling it.
It sounds as if you love it.
I do. This is, as I tell my kids, I've got nobody who could get into NYU, but I've got a boy that just got out of Brown, and I've got a freshman who's a football player, and yes, I do let him play football, up at Cornell, and I tell them constantly, whatever you want to do, you want to be a doctor, you want to be a lawyer, you want to be a banker. I tell my younger one he's more likely to own an NFL team than ever play for one, and that's important to remember as he stands on the sideline at most of his games up at Cornell, that if you don't wake up every day somewhat jazzed about what you're doing, that life is really a drag. And if you don't like this stuff, don't do it. Don't do it to become rich. Don't do it to be on TV. Don't do it for any of the reasons that seem like they're attractive. And yeah, they think their dad has a cool job, but I do it because I love doing it. I don't do it for the, for the glory, if you will.
You love it, Greg?
Most days, not every day.
Most days.
It's,
Well, one day you were up before the Supreme Court in American Needle, right?
I was.
How was that?
Well, it was fine until we got the decision.
Yeah, on the other hand, Greg was also up before the Supreme Court 20 years ago in the Brown case, and that worked out quite well for him.
One turned out all right.
Yeah, you were also in the Sixth Circuit, and you beat my ass.
I wasn't going to mention that.
Well, you had an advantage. You had 3 hometown judges.
That was true.
This was a case against the Bengals about some of the activity relating to the financing of the stadium. So it was Hamilton County, which was in effect the class, versus was it against the league or
It was against the league,
Bengals?
and the claim was that the league's relocation policies limited the county's option, and in effect, they ended up paying a king's ransom in order to get the Bengals to stay in Cincinnati. And in fact, the Bengals have probably the last of the entirely publicly financed stadiums in the NFL. They brought an antitrust case. We prevailed on summary judgment. And I found Professor Miller across the aisle when it came time to argue the case in the Sixth Circuit.
So I'm a loser, he was a winner. If I'm going to lose, it might as well be a former student.
Very fair. Very fair. But you asked, do I love it? And the answer is, most days I do. The work is terrific. The work is fascinating. It's very interesting. It's very engaging. The stakes are high. So the clients are prepared to ensure that everything is done the right way. There's no sort of cutting corners. My clients are very sophisticated, as I'm sure everybody's are. They know the difference between good legal work and bad legal work. They are probing. They ask the right questions, and it's very satisfying to see something come to completion, whether it's the antitrust litigation in Cincinnati or negotiation of a collective bargaining agreement, which Jim and I did now 5 years ago. Once those matters are done, you have something to show for your efforts.
Remind the audience what that labor management dispute was 5 years ago.
Well,
It was
that
big. It was a big.
Yeah, it did get a little coverage from time to time. That was we were coming to the end of a collective bargaining agreement that had been entered into in 2006, and the NFL had pulled an early termination trigger, and we got into negotiations. The NFL wanted what I will essentially say were givebacks. We didn't want to have givebacks. We wanted to have give us. We ended in a stalemate. They filed NLRB charges. We decertified the union. This
Why
was
should decertify the union?
in order to be able to sue the NFL under the antitrust laws.
Otherwise,
Otherwise, the labor exemption would, under the Brown case that Greg successfully argued back in the mid-'90s, they would have the labor exemption. So in order to get around that, we decertified. And the judge at the district court level, we were in Minnesota, Judge Nelson upheld the decertification and entered into an injunction enjoining the NFL from continuing their lockout. Unfortunately, the NFL, those pesky NFL appellate lawyers, we went to the Eighth Circuit, and by the way, during this process, there was collective bargaining and mediation and various things going on, and eventually the Eighth Circuit, on what I still believe to be very narrow grounds, decided that the injunction was improvidently granted because of the Norris-LaGuardia Act. I won't get into the interstices of that argument, which was ridiculously complicated and also wrong. And eventually, as a result of that and other things, we got back together and collectively bargained, and they got some stuff back, and we got some stuff as well.
Yeah, that's known as the Brady case,
It would be Brady as in Tom, yes.
as in Tom, as in Patriot, et cetera, et
I
cetera.
mean, one of the more interesting things is how it ended up being the Brady case instead of the Manning case or the Breeze case, because everybody wanted to be the first name plaintiff. And so we were debating we were going to actually figure it out, and then we decided, well, we'll just do it in alphabetical order. And it turned out Brady was first.
Is your view of that case the same as Jim's?
The outcome of the case was the right outcome. The Norris LaGuardia Act's application was clear. I do acknowledge that Jim got a vote. It was a split decision in the Eighth Circuit, but it was the right outcome. And it was the Eighth Circuit is generally viewed as a reasonably pro-business court, and their views, they had a track record on labor-related issues. But it's no accident, I should add, that the case was initially brought by the union in Minnesota, which has been Jim's forum of choice for, I don't know how many years now, to 30
Actually,
years?
I'm going to tell you a quick story, because, which is the truth. When we filed the McNeil case, we did not file it in Minnesota because the Eighth Circuit had come down with a ruling which was not quite as bad as Brown, but close to it in terms of the extent of and how you would decide when the labor exemption would end. So what we did was we actually filed it in New Jersey, and it was the NFL who moved to transfer the case to Minnesota and in front of our good friend Judge Doty. I think a motion that they now, in hindsight, probably regret.
Absolutely.
Doty had been a friend in the past, so.
Well, Judge Doty ended up being the judge that supervised the collective bargaining agreement that was reached in 1993 through, he was still deciding issues through 2013 or 2014. And he was a good friend to the union. I think he was, if you were to line up the wins and losses, Jim and his colleagues had more wins in Minnesota than my colleagues.
We just looked at him as an enormously fair judge.
So tell us about American Needle. Those of you who haven't taken antitrust or haven't taken labor relations, you should get some sense that a lot of the activity of a sports lawyer, however defined, is what's in the antitrust column and what's in the labor relations column. And you heard words like the labor exemption. If it's something under the collective bargaining agreement, you are literally exempt from the antitrust. So there's a lot of pushing back and forth. Oh, we're in the exemption or we're out of the exemption. Well, American Needle was an interesting case.
The core issue in American Needle was whether the members of a professional sports league, the member clubs of a professional sports league, are a single entity for purposes of Section 1 of the Sherman Act, or whether they are multiple entities, in effect competitors. And the context of the case was a lawsuit brought by American Needle, which is a manufacturer of baseball caps, which had been a longtime NFL licensee. And in the early 2000s, 2000, 2001, the NFL decided it was going to change its business model. And it went from a situation where they licensed a half dozen or 10 cap manufacturers to only one. And Reebok got the exclusive license for caps as well as other apparel. And the issue that we moved for summary judgment eventually, arguing that Section 1 of the Sherman Act didn't apply to the NFL and that sort of collective decision, because the clubs should be treated as a single entity for purposes of the antitrust laws. That is an argument that has been advanced throughout the 20 or 25 years that I've been doing this work, almost always unsuccessfully by the leagues.
Yeah, in the soccer case and also in the Raiders case.
In the Raiders case and franchise relocation cases, it was sort of consistently a loser, but we kept making the argument. And we finally found a judge who would buy it. In the Northern District in Illinois, Judge Moran, may he rest in peace, ruled our way and basically granted us summary judgment, saying that Section 1 didn't apply to the member clubs of a professional sports league acting collectively. The Seventh Circuit affirmed, American Needle then sought cert, and in a sort of calculated move, we recognized that this was sort of a once-in-a-lifetime opportunity. It was an opportunity to change the law everywhere else. We had a conflict among the courts now. It was a clear conflict between the Second Circuit and the Ninth Circuit and others in other cases in other sports on the one hand and the Seventh Circuit on the other. So we supported cert. And it didn't work out the way we had hoped it would, but from our standpoint, we had very little to lose because after that Seventh Circuit decision, no antitrust plaintiff's lawyer was going to file another suit against a sports league in the Seventh Circuit. And the amount at stake in the American Needle case, from our standpoint, was not all that significant. In fact, just a few months ago, 11 years after the case was filed, we finally settled the American Needle case for a modest sum. But that case, I think, addressed the one issue that distinguishes, in a doctrinal notion, the antitrust laws as they apply to professional sports from the antitrust laws as they apply to other industries and other businesses. What we call the single entity rule.
We and the players, this is one time that all of the players' associations got together and filed an amicus brief because notwithstanding some language to the effect that the NFL said in their briefs, well, we're not saying this should apply in the labor. We were terribly afraid that the Supreme Court would rule in some way that they would now have yet another defense in the antitrust laws beyond simply the labor exemption. Turned out the Supreme Court came out the right way, saying essentially that the single entity defense was nonsense.
What was your sense while arguing the case of the justices and their knowledge of sports or their attitudes towards sports?
Well, I think the justices were engaged, but they were more focused on sort of antitrust doctrine than anything else. It's interesting, I don't remember the number now, but at the time of that argument, which was probably in 2008, there had been a series of 16 or 18 antitrust cases brought before the Supreme Court over a period of 12 or 13 years, and there had been 16 or 18, 100% wins for the defendants. So we went into the argument knowing that it was going to be a long shot, but we did have this sort of streak that was going. What we didn't count on is that Justice Stevens, who was a very pro-plaintiff antitrust scholar, this was his last opinion. And he wrote the opinion, and it is clear to us that the other justices must have given him free rein because it was, even though I think the outcome was probably foreordained, the language of the opinion is very, very aggressively in favor of the plaintiffs, more so than I think the doctrine would warrant.
Do you think judges are pro-plaintiff in the sports context?
I can think of one.
My experience has been, and this is usually the way that we used to look at it, is you don't want a what we call the chucklehead judge. And by that I mean a judge who's a real big fan, because almost invariably they would side with the defendants. You wanted somebody that had less involvement in sports, because they would tend to look at. Is the reason one of the reasons we ended up, Greg knows this, in the McNeil case, we ended up with 9 women on the McNeil jury. It was an all-female jury, and our testing. Our jury testing prior to that indicated that at a level that I'd never seen before or since, that women voted with the players. And because we had a simple theme of, it's America, people ought to be able to go where they want after their contract is up. Whereas the NFL, and it's not just the NFL, the other leagues have always tried to defend their illegal rules by saying, well, we need them for competitive balance. one of the more nonsensical arguments in the history of the world. The NBA argued competitive balance in the early 70s, even though the Celtics had won 10 out of the last 11 championships. So their rules really weren't supporting competitive balance. And if you go through, I actually put Don Fear on when he was still with the baseball players on the stand, and he went through in baseball how, which was totally true, how after the reserve system collapsed, that for the next 10 or 12 years, virtually every single winner, with like 2 exceptions, were from small cities. So this whole notion of competitive balance is pure silliness.
And I would just add one quick thing to that on this, I think your term was chucklehead?
Yes.
Chucklehead. I have a term for that, but it's so pejorative, I don't want to say it.
Just stay with chucklehead.
But it doesn't necessarily relate to judges, because I had it from a different perspective. I can understand when these guys are fighting, why that's a concern. So you got, the NFL, and you represent
Players, yeah.
the players, but you're dealing with, for the most part, you're dealing with probably an executive in the union. That's probably who you're talking to. And you're dealing with Jeff Pash and people like that. Some of these lawyers out there that are representing the players are a nightmare. It's a real problem. I mean, they're fans. They're more fans than lawyer. And it's something I had to deal with in this case in a way that I've never had to deal with it in my career. People that are objecting to the settlement simply because they don't want to tell this player who they idolize that this is really the best deal for him. Or one lawyer who was a business lawyer for a very famous, now deceased, retired player who could get $4 million in this without having to prove causation or anything like that, yet he's convinced the player's family that they should take a chance at a trial. And these guys are chuckleheads. I mean, because if they're thinking like lawyers, they would analyze this like a lawyer and think, yeah, $4 million is a pretty substantial payout with all the risks involved here, and these are kids involved, and they could probably use the money. They don't have a dad now. But, I really don't even care if he sees this video, and he'll know who I'm talking about, particular lawyer. But it's one of the fights I've had behind the scenes with lawyers, is, you got to stop being a fan. Don't be a jock sniffer. Tell the guy what he needs to hear. Tell him that what's good for him and what's not good for him. And that's a problem, I think. And it's probably a problem not just in sports, but with all celebrities. Not making good decisions about cases because they want to be fans more than a lawyer.
Do you run into that in the deal-making environment where these rich folks are probably big fans, or some of them are big fans, like some of the people who took over the Dodgers?
Yeah, it's interesting. I was out in Los Angeles for IMG's World Congress last week, and
That's Borland's phone.
good tune. Is that for me? But there was an owners panel that Vivek Ranadive, who owns the Sacramento Kings, Joe Lacob, who owns the Golden State Warriors, and a guy named Will Chen, who owns DC United in the MLS and part of the San Francisco Giants, spoke on. And they got into a debate with Vivek arguing, yes, he loves the NBA, but he was economically incented when he agreed to pay the price that he did about a year and a half ago to buy the Sacramento Kings. And Will Chang, who's the guy behind $1 Million Arm and the movie, who said, he said, I've got a diversified portfolio. I'm a private equity guy. I look at sports and media as one ecosystem, but as a sector in my portfolio of assets. And when I bought these 2 teams, I did it like I was buying a piece of art. He said most people, when they bid for a piece of art, they overpay, because in order to win the bidding, you've got to pay more than the second highest guy, right? And he said, I probably overpaid at the time for each of these 2 assets. He said, that said, art tends to appreciate. All of these teams have appreciated immensely. And so they were both great buys for my portfolio of companies. But I view it as more of an art purchase than a strictly economic decision. So I would say, look at the guys who came along from Blackstone, Apollo, and some of the other firms to buy the Sixers. They got the Sixers for a great price. It was before the new collective bargaining agreement. It was before the NBA's $24 billion TV deal. These guys, when and if they sell, will make a fortune. They'll look like some of the smartest investors on the planet. And by the way, Josh founded Apollo with Leon Black and a few others. He is a very smart investor. They did it. These are a bunch of guys that went to Wharton together. They did it both because it would be fun, it was reachable from New York, and you could be back home in your own apartment or house with your family that night. They did it to bring their kids to games, and because they thought it would be a lot of fun, knowing all along, because none of these guys are sort of loose with their change, that they would make a lot of money in the end. And so I think, Arthur, it's really a combination. I think they wouldn't buy unless they were fans, but they all recognize the economic, the accretion of these teams over the years, and for that reason, they can sort of, imbibe their passion and still make money.
You think the Clipper purchase price was a good deal?
So, look.
$2 billion.
The way these deals sort of happen now is you either have a whale investor like a Steve Ballmer who can afford to spend $2 billion to buy the Clippers, or you have a bunch of high net worth guys coming together who maybe or maybe not could afford to do it, but don't want to put $2 billion of their own money into the team. And so you'll have a group of private equity and hedge fund guys coming together to make the purchase. We're seeing that on the buy side of the Hawks in spades right now. If you look at the tax implications of what Steve did there, and I and probably several other lawyers had the second place bidder, I was told. He's really not paying $2 billion because the U.S. tax code allows you to write off goodwill over the actual basis
Don
in the
Sterling
team.
is goodwill.
So the goodwill in that team was huge compared to the net asset value. And so if you look through the analysis that Bloomberg, Forbes, and a few other publications did, he actually paid, given the write-offs that he'll be able to make against his performing assets, probably closer to $1.25 billion. He's had a great run in the year that he's had the Clippers. I don't know that he'll ever, I don't know that the Lakers will ever become irrelevant in Los Angeles, regardless of how bad they may be in any given season. I think at the end of the day, he didn't care. He liked basketball. He liked the idea of coming in as a white knight on a white horse and rescuing the league from this, arguably terrible person who said some horrific things and who deserved to be booted from the league. I thought Adam acted really strongly in that situation. And so I think you had a lot of the kind of perfect storm set up for Steve to do that. You had a team that was going to be sold in a week. You had all of Hollywood, from Oprah Winfrey to you name them, coming out to bid. He knew he'd have to pay a really high price to get the team, but he also knew he'd be perceived as a hero, and he could afford to lose the money. And so, did he overpay? Time will tell.
Time will tell.
If you look at the track record, though, of the NBA teams over the last 25 years, if he holds on for 5 to 7 years, I would say he did not overpay.
Let me ask you about another transaction. I think you were involved in the formation of New York City Football Club. Now, that's an interesting one because it's Manchester City group tied to Abu Dhabi. It's really a global sports empire that is in progress of being formed and will expand. And 20% of it is owned by the New York Yankees, which I hope is a good investment because the team they fielded this year is so bad. What was that like? A global deal, sort of.
Arthur, that's a great question. And people look at the NBA as the most global league for a lot of reasons, and I think for a lot of very good reasons, including NBA China, the fact that 25% of the NBA players come from foreign countries. You've got 340 million NBA fans in China. That's more than the U.S. in total. And they haven't even tapped their international properties. So if you were buying into the NBA, a 1/30th interest in the NBA, because there is a scarcity value, you're buying 1/30th of a global growth safe stock, if you were going to look at it that way. While the NBA may be the most global of leagues, that deal that you're describing, we represented Abu Dhabi United and Manchester City, in partnership with the Yankees, is truly, in my view, on the M&A side of sports law, the most transformational deal that's happened ever. Because what you had is, you have Abu Dhabi United, which is in part using this as a branding exercise as they, as they illuminate people to the fact that Abu Dhabi is not necessarily the same thing as Al Jazeera or the same thing as Al Qaeda, because sadly enough, many people don't know that, okay? Abu Dhabi is a country, and I know of NYU's relationship with Abu Dhabi, that is not Al Qaeda. They own Manchester City, and they did something very transformational, which is they said, we're not Manchester United, but we want to compete on a global basis with Man U, not just for the Premier League championship, but around the globe to be a powerhouse organization. Man U is Man U. You can't beat them by just, landing great sponsorships and, great TV deals. We need to go and we need to buy and stake our flag in a bunch of different jurisdictions. So they bought in New York. We bought for them in Australia. We bought for them in Japan. There are 2 or 3 others coming down the pike because Ferran Soriano, who runs Manchester City and who ran Barcelona before that, said the only way we can build a global brand is to buy it, and we have enough money to do it, so let's do it. And Sheikh Mansour bought onto that theory, and so they've done it. But what MLS, behind Don Garber and Mark Abbott, have managed to do that no other league, including the NBA or the NFL, is have the most iconic, arguably the most iconic U.S. sports team, certainly in Major League Baseball, team together with one of the most iconic teams in the Premier League to buy into their league together. That's never happened before. You've never, ever seen a team from one league buy into another league. And by the way, how about a team from the Premier League, which is, it's been around a long time and it's very prestigious, buying into U.S. Major League Soccer. So what that has done, in addition to the fact that you got the Yankees teaming with Man City, playing in New York City, presumably creating a rivalry with Red Bull, which I suspect we'll see soon as that develops. They've only played a couple of games so far, is lifted, it's sort of the rising tide will float all boats, but it has lifted the value of every other Major League Soccer team in a very significant way. So we bought the Atlanta team for Arthur Blank, the Orlando team, the Minnesota team we're working on now, and we're working with Kevin Johnson, Mayor Johnson of Sacramento, in trying to land an expansion team in Sacramento. We also did Chivas. So the teams are now selling for 100 plus, and the plus is some number more than 100, and you need to build a stadium. If you don't build a soccer-specific stadium, which New York City Football Club is working on, you can't have a team. And that's been one of the strains in awarding franchises. So what you're talking now is, depending upon where you live, it's obviously more expensive to build in New York or LA than in Sacramento. You're looking at a $250, $350, $450 million price tag. When we bought DC United for Will Chang a decade ago, he paid $30 million. And DC is not a minor media market. So look at what this deal, and I would argue in part that it was primarily this deal and their new television contract did for Major League Soccer. It's really put them on the map. And while, Jim was laughing about soccer being the sport of the 80s, I thought it would be. My kids played that till they switched to football. I think we're finally seeing the generation that's going to make soccer the sport of the next couple of decades, because I think it's got a great, attractive, passionate, loyal fan base, and I think we're going to see it finally in the U.S. happen.
Jim and Greg, is there peace in the antitrust CBA area now?
There continue to be skirmishes.
Skirmish.
So the front is not totally at peace, but things are better than they were in 2010 and 2011.
I think that's true in football. I think be interesting to see what happens. You know, baseball has a contract coming up. I don't know which sides are looking for what in that context. I do know that in basketball, we have 2 years left to pull a trigger with regard to that deal, and for a lot of different reasons. One, not the least of which is the enormous increase in franchise values in the NBA, plus the new television contract, which comes into play a year before the trigger mechanism goes into place. It's likely that there will be some very heavy bargaining over the next year or so, and hopefully that'll work itself out. But there's a possibility. I can see some clouds forming on the horizon with regard to the NBA in 2017.
Early in the discussion, Chris said one of the issues in the NFL concussions case is really the scope of the CBA, what it covers. If you pick up the newspapers, which I do since I'm an old fogey, you see the constant reference to player behavior in one form or another, whether it's Peterson, whether it's Ray Rice, et cetera, et cetera. Now, were these covered by the CBA? The discipline of Rice or the discipline of Peterson?
I'm going to leave that to the two experts on that, but there is one thing that there's a point I wanted to make about this, if you don't mind me changing it just slightly, but I just find it odd, and maybe others think it, but it's really odd to me, maybe it's a commentary on our society, that we get cues about what's appropriate conduct in terms of racism or domestic violence. We're getting those cues from sports teams. I mean, you know, firing this knucklehead who owned the Clippers was the right thing to do. I don't know if legally it was achievable, but it was the right thing to do. It was the moral thing. And Ray Rice punches his wife, and now we're all, and I don't mean just talking about it over dinner. People who own and run offices are talking about what the appropriate, and they're getting their cues from the NFL on that. And I just find that, I find that sad, to be honest, that we're getting those cues from sports teams,
that's it.
and that they're not following our lead. But, you know.
It's interesting that you say
Good that it's
sad,
happening.
because, you know, I'm an old fogey. I go way back. I'm used to using a quill and an inkwell. When I was growing up, the notion of sports appearing on the front page of the New York Times was inconceivable. Yeah, in October, Yankees won the World Series. That was it.
That was the headline.
And as you properly point out, player behavior, whether it's performance-enhancing drugs or indirectly concussions or domestic violence or child abuse or just thuggery, increasingly creates a national dialogue. The Ray Rice event created a national dialogue.
Yeah, you could have seen the same scene played out in an office, and we wouldn't have created that.
That's right. That's right. Now, that tells you something about the penetration of sports in our society and the implications of sports on our culture.
And one could argue what's wrong with our,
Well,
sorry guys, you make a living.
It does, Arthur, but I mean, a lot of this is due to the fact that you have 24-hour media coverage. You've got ESPN 1 to 1,000, you know, Fox Sports, 93 different regionals, et cetera. There's constant coverage. There's a need, whenever you have the media, there's a need to feed the media. And as a result of that, and because sports is now what it is, these stories that happen, you know, sadly everywhere in the United States, but if it happens involving an athlete, it's going to get far more coverage.
So is this entertainment law more than sports law? I mean, maybe there.
Well,
maybe it's not
Chuck
sports.
earlier referred to sports and media as a sector.
Yeah.
And anyone thinking about a partial or full career in this thing called sports law really has to think about, do I mean representing players? Do I mean representing a league? Do I mean
Well, the union, which is different. I mean, it's a different.
representing
Can't make all the players
ESPN?
Or does it mean anyone who wants to hire you, will I represent them? That would usually been my my coda. But yeah, sure, sports and media do bleed together. There's no question about it.
I co-chair a group called the Global Sports Media and Entertainment Practice. So think about that. It's global, it's sports, it's media, and it's entertainment. And I think it's virtually impossible to distinguish among
Sure.
the three.
Good, bad, or indifferent? Do we like compartments, or do we like it to flow that way?
As law firm partners who are asked to chair groups, we love it, because the broader the mandate, the better and the more business you can bring in. So when Al Jazeera comes here to buy Current TV, which we did, you can be an M&A lawyer and still do stuff like that. That's media, right? That's not sports, even though they own beIN Sport and they own Paris Saint-Germain in the French league. But yeah, I think we'd like to see it, and I think we would be fools not to recognize that were it not for these cable deals and the RSNs, that the leagues and the teams are striking, these teams would not be worth a fraction of what they're currently worth, nor would the leagues for that matter.
Greg, you're nodding.
No,
I hope not sleeping.
I think what Chuck says is exactly right. That, and Jim's point is true as well. You know, there was a time when the NFL was covered from August to January, and that was it. You didn't read much about what happened in the NFL during the rest of the season. Now it's a 12-month process. Whether it's the draft, whether it's the combine, there is just an insatiable demand for content, and as a result, it puts these players and the leagues and the teams all in the spotlight, and when there's a stumble, everybody hears about it.
Who the hell would ever have thought that the draft would be wall-to-wall TV coverage?
And they're moving
insane.
it from city to city to make more money. So I was at Radio City last year. I like to go to the draft. It's only a block from my office. I won't go in other cities because I don't like it that much. But the NFL is very, very shrewd about marketing their best assets, and the draft is really a lot of fun. So for them to have cities bid for it, like they do for the Super Bowl, was really a very smart business decision that they probably could have made a decade ago, but it's still a great decision.
Yeah, and you could ask, is March Madness sports or a TV event? I mean, the world stops during March Madness.
Well, since I represent CBS, we look at it as both.
Well, you got a good deal there.
Yes.
So what are the issues for the future? Is player behavior containment or intrusion on player behavior, commissioners' powers? No. The greatest autocrat in the civilized world is the commissioner of the NFL.
Oh, I'm not sure he'd agree with that. But I think.
Come on, wouldn't you love to be commissioner of the NFL?
Oh,
I
perhaps
mean, let's
someday.
face it, your name
That's a
has
cool
been
job.
mentioned as a commissioner. Would you like to be a commissioner?
I'm quite happy being the lawyer for the National Football League.
Sounds like he's running for president. You don't want to announce. He doesn't
And
want
I,
to
and I
declare.
think Commissioner Goodell will be the commissioner for many years to come.
You know, 3 of the 4 commissioners of the major sports, as now defined, are lawyers.
Yes.
They're lawyers.
I think that, to some extent, that's a reflection of the importance of the labor relationships and collective bargaining over the term of their tenure. That was a natural seeding ground for potential commissioners. May change in the future, and Commissioner Goodell's not a lawyer.
No,
That's
he's the
that's a
one
good
of the
example.
4.
Yes.
But I had the pleasure of doing a conversation with Adam Silver about a week, 2 weeks ago, and we went through his career. You know, by God, he's a University of Chicago law graduate. What University of Chicago law graduate goes into sports? And of course, he didn't. He went to Cravath. And after a couple of years of Cravath, basically, David Stern, who had had a relationship, the 2 families know each other.
With his father, with Ed Silver, who was
Yeah.
one of the great labor lawyers in the United States back in the 60s and 70s.
So he moves over to the NBA, graduates, and now he's David Stern. That's a dream. I mean, how do these people who are interested in sports law plan to do that? Or is it just dumb luck? Didn't
Well,
you
for me, just keep going to urinals. You never can tell what can happen.
I think,
I think it's a story for everybody is different, and it is really, to some degree, dumb luck. When people ask me now, because people do focus so much more on the sports practice and sports and entertainment practice, when you graduate from NYU, it's a great law school. In order to end up, if this is something you really want to do, you need to go and hone your skills for several years at a good firm, hopefully one that has some sports and entertainment background. There are a limited number of jobs out in this world. The corporate area has grown significantly because of the value of these franchises. Years ago, that was not really a big deal, but it is now. You've got the leagues, you've got the players' associations, individual clubs. Count them up. There's not that many jobs out there, and so it's tough to break into it, but you need to have honed your skills in negotiation, in contract law, particularly IP, some antitrust, because all of these are the issues that will likely come up, and of course, on the corporate side, in finance and M&A.
so I hate to wear my dad hat, as my kids call it, but I've got two boys. So one is, I said, you got to like what you're doing or you're not going to do it well. So that to me is sort of sine qua non. There are some values out there that I think we all believe in, besides being lucky, which is really important in life, that I think can contribute to success. So I would say, and I've got a view, learn a skill, whether it's sales, M&A, litigation, antitrust, whatever it is, hone a skill. You can always apply that in the business of sports. I think everybody wants to be in sports, or many people want to be in sports. It's very hard to get a good job in sports unless you know somebody kind of straight out. So I would always say, develop a skill first. Work harder than everybody else. Adam Silver is one of the hardest working guys I know. He leaves the NBA after everybody else has left. Commissioner Goodell is, they're all ridiculously driven people. Work harder than everybody else. Be genuine. Be honest. Be loyal. Make friends where you go. Treat the people you work with properly, with respect. Adam, I think, and Roger are great models for that, and I don't mean to take anything away from Rob or any of the others. But if these are just kind of life skills that you could pick up in kindergarten, not to be corny, but if you treat people with respect and you work hard and you're loyal, and you get lucky to hit the right urinal, I think you can make it in this profession. But I do believe if you can develop a skill first, it makes life a lot easier.
And Chris, going to the other side of how do you become a plaintiff's sports lawyer?
Yeah, I still, I don't know how you'd become a plaintiff's sports lawyer, because one thing I think that we'd all agree on is that if you consider yourself a trial lawyer, you're going to have a lot of different cases, fall in your lap. On the plaintiff side, I try all kinds of cases, from defective drywall in the Gulf to case against Merck to, this case didn't go to trial, but we were prepared to if we got to a jury. And, I think that's one of the fun things about being a trial lawyer is you get all kinds of different cases, and it keeps life exciting, and I love what I do, and everyone here loves what they do, and you guys hopefully will too. But I don't, I'm not looking for sports cases. I don't have a real particular
You keep
interest.
saying that.
Yeah, I got to be honest with you. It's I do what I do. If something happens and it falls into my lap and there's a fact pattern that I feel sets up a good case, in the instance of the NFL, and I don't want to give Greg any agita here or pick on them, because as you know, we are settling. But, there was a sweet spot in that case that involved a period of time where I felt that the NFL, covered up what they knew to the players about concussions. That set that case up, and I think they know this, that set the case up and made it attractive for somebody like me to say, looks like some bad conduct that we could go after. As I said, I didn't bring case against the NCAA. I didn't bring case against the NHL because they had pretty good return to play rules, and they didn't have this sort of committee thing that went on there. And, so I've passed on all cases that have been brought by somebody, but I've passed on those. So, and I would be pretty happy if I just go back to handling my cases where I represent Mrs., so-and-so, who, took a drug and was injured by it, and I enjoy. I mean, I became a plaintiff. I started out at Sherman and Sterling, which is a big defense firm. I liked what I did. I felt I learned to practice law, but I wasn't satisfied. I was a carpenter. I put myself through school as a carpenter, was a union carpenter, and I just, ideologically, I became a plaintiff's lawyer because that's what I wanted to do. I knew I wanted to be a trial lawyer because my first case was representing Mrs. Morgado against Pfizer, and she grabbed my arm as we walked into the courtroom and held my hand under the table during the trial, and I fell in love with what I believe is the white knight role. That's what I fell in love with, and that's why I continue to do it. So when the players came to me and I met with them, you know, I fell in love with the particular guys I had there, with their concern for their injuries, but, you know, and I took the case for that reason. Now, I made a comment before, which I really think is important. You also, as a lawyer, you have to be honest with your client, and I had to honestly advise these guys when I thought the settlement was right, take the settlement, that you know, even though it would be great to represent a big name against the NFL at trial, I would rather have a really good chance at winning the case. And if the alternative is a settlement where there's no proof of causation and you could be compensated, well, yeah. But anyway, so that was a really long way of saying, I'm not looking for any more sports cases, but if a good one falls in my lap, I'll take it.
Well,
I like trying cases.
there are a couple of plaintiff side lawyers litigating in the IP area
Yeah.
now,
Yeah,
which is sort of a
Yeah.
21st century.
yeah. Yeah, I wasn't, I mean, and there was another case in Minnesota involving merchant. I wasn't very interested in that case either, and I frankly don't think, you know, I don't want to be critical of the result of that case, but it didn't result in a really big, there was not a big result that came out of that. So, I mean, like I said, I like handling cases and trying cases that have a lot of upside for my clients. And, you know, obviously, there's a big risk and expense for us. We work on a contingent fee. And I like to try cases, and I like to have a chance of winning. So,
Are you in
crazy.
any of those IP cases?
Yeah, on the other side, we represent CBS in a couple of cases where this is a new thing now. It's a fallout from O'Bannon, which you know, many of you probably are familiar with, where there's a group of plaintiffs' lawyers, mostly West Coast, who are bringing lawsuits. One case is down in Tennessee, which is alleged conspiracy among the networks and conferences to agree to not pay student athletes for participating or for their, allegedly for their rights of publicity. That case was just argued this week. We have another case on the West Coast for CBS itself because they were selling photographs of college athletes, and there's a putative class action which we're litigating. Yeah, O'Bannon and Keller, the two cases on the West Coast, have spawned a lot additional litigation.
And it's sort of interesting that these are right of publicity, name and likeness
Yes.
type cases. It's
Yeah,
like
yeah, that's what they are.
the amoeba that ate New York. It's just
Well, I mean, one
sprung
of the
up.
things that's happened is, for those of you who are looking at this, is right of publicity was something that basically came out of a case, a Supreme Court case back in the 50s, with the Zucchini case, whatever that, Zucchini case.
Zucchini. Or Zacchini.
And Zacchini, and also the New York State Public, or Section 51, their right of publicity law. And essentially, it was intended initially to focus on taking a picture of someone and then using it to advertise a product. And that has now morphed into a lot broader categories, and hence why we have so much litigation relating to it.
Yeah. The economic value of a performance.
Essentially, yes.
Yeah.
Yeah.
And my name or your name and likeness is
Right,
worth
mine
something.
wouldn't be worth a lot, but yours could be worth a hell of a lot.
Well, my name is worth a lot. I write plays. And I was married to Marilyn Monroe. I have other fantasies as well. All right, it's your time. Let's have questions or observations for our four panelists. Yes, sir.
There are a couple of cases going on involving baseball's antitrust exemption. One's a consumer class action here in Southern District of New York, dealing with the regional TV deals of MLB and NHL. And another is the relocation case of the A's involving Oakland and San Jose. So my question is, what is the practical effect of baseball's antitrust exemption? are there things that baseball can do that the other sports can't do? Or does it put baseball in a stronger position in dealing with players' unions and other third parties?
Do you want to?
Well, let me start, but Greg can, jump in as well. Look, at least as of now, the Curt Flood case is still good law. And so, therefore, the law of the land with regard to baseball only is that, with the exception, because they've now carved out labor because of the Curt Flood Act in 1998. But putting that aside, yes, I think they have a broader ability than the other leagues to do certain things because of their antitrust exemption. Is it stupid? Yes. Does it make any sense? No. And I think, some of these plaintiffs are hoping that they can maybe get it up to the Supreme Court. You mentioned 2 cases. I think there's a third out there somewhere. But there's certainly a possibility that, depending on how they get ruled, that they'll have a shot at getting it back to the Supreme Court.
Yeah, the California case is the perfect example, the relocation case, where it's almost automatic that, it was almost automatic that the court ruled for the league, and it's going to the Ninth Circuit. But I don't see any prospect of that situation changing. The courts are unwilling to adjust the doctrine in any way or cut back on the doctrine, and the Congress has other things to keep them busy.
And frankly, it's hard to see why the Supreme Court would take the case other than to say we were wrong in Flood, and they don't often do that.
Yes.
Hi, everyone. My name is Ashley. I'm a senior in the undergraduate program focusing in sports law. Thank you all for coming. This is really insightful in general. My question is more generally for all of you, being that sports is such a personal relationship game. Essentially, you need to know as many people as you can and foster these personal relationships. In general, how would you say, at the same time, sports also is very personal. People can take it very personally. So how have you mended and nurtured these relationships over the long term of your career in order to preserve them at times when things became difficult? It seems like, Mr. Quinn and Mr. Levy have had previous experience working with each other. Things didn't always go to, you both couldn't always win. And so how did you make sure those relationships were intact over the long term? Is there some kind of fruit basket etiquette that I'm supposed to know about? Or, just generally, how do you make these things work over the long period of time?
In our case, it's very easy because we knew from day one, and every lawyer involved on each side of this battle knew from day one that it was going to be a continuing relationship. It's not a one-off lawsuit. Chris, I'm sure, has plenty of one-off lawsuits in his career. He sees a lawyer for one case, and that's it. We know we're going to see the same lawyers in the next case, and the case after that, and the case after that. As a result, professional respect, courtesy is really the order of the day. It's in everybody's interest to do that.
Yeah, no, I completely agree. I think that makes, at least on the labor and employer side, in all of the sports, that is the case because there's a relatively small group of people who are involved in this on both sides, and you couldn't exist if you were constantly burning each other's bridges. You know that eventually you've got to get to a deal.
Yes.
Hi, thank you for coming. I'm Peter Xavier. I'm a 1L here. Very interested in the international expansion of American sports in particular, particularly basketball. And so I think, Mr. Barker, you mentioned developing skills that could make one, could help you sort of contribute value to an organization. I'm wondering if you have any insight from maybe conversations you've had with your clients on what sort of skills they're looking for. I'm sure there are lots of great lawyers, a lot of great people who can do M&A, accounting, et cetera. But other skills, data skills, foreign language skills, cultural competency, are there any other things that wouldn't just be some sort of ancillary footnote on your resume, oh, I speak Spanish, but could actually be a really core skill to help add value to your client?
It's a great question. So it's Baker, but I didn't want to correct NYU here. So look, each of the leagues has made it fairly clear, particularly the NBA. The NFL is playing games in London now. They've got an owner named Shad Khan who owns Jacksonville and Fulham, who's a businessman with interests in the Middle East, where it makes good sense for him to have properties on both continents. Baseball has obviously expanded significantly into South America, Cuba. I think I go back to what I said earlier, which is developing a skill, whether you like to litigate, you think you want to be a corporate lawyer, you want to be a finance lawyer, working hard at developing that skill. I think language facility is critical. I know that the leagues are generally looking for strong people who can help them with their international expansion efforts. And so I still think it goes back to they're looking for the best candidates in terms of the most skilled people for the positions, but the language facility and experience living abroad, I think, are big attractions to the leagues in terms of their expansion.
Last question.
Hi, everyone. My name is Tian Yuzhen. As an international student, I've been very interested in sports law. One of the reasons is that in my country, there are a lot of sports-specific laws or regulations, which is quite opposite from here. And my question is, do you believe that sports particular laws or rules or regulations would limit the free market or the economy of sports industry? Thank you.
Greg?
Well, there are a number of rules and practices that limit the free market that, from our standpoint, are essential for the success of the sport. For example, all of the complex arrangements for player relationships, the draft, restricted free agency, those sorts of things are, they limit the free market for players. It's clear that there are pro-competitive and constructive reasons for those rules. How they would play in terms, and how they would be evaluated in terms of another country's legal system, I couldn't tell you. But I think inherent in the structure of the sport, the limitation of the number of teams, the limitation on the number of players on a team, all of those are restrictions of what might otherwise be perceived to be free market forces. And those restrictions have turned out to be constructive and productive. But I couldn't tell you how they would be evaluated elsewhere other than the United States.
And let me just add, when we're advising owners, when Abu Dhabi United, owners of Manchester City, were looking to invest in a league, they went to the European Premier League. Why did they go there? Because they looked at the US and they saw how heavily regulated and structured, including things like collective bargaining agreements, these leagues were, and they couldn't just come over here and buy a championship. They went to Europe and they bought a championship. They were able to spend money freely, like Russian oligarchs did before them, to buy the Premier League. And the Premier League, learning from the US, is starting to rein that in a little bit. They now have the financial fair play rules, which is an attempt at something like a luxury tax, which we have here, but it's not nearly as rigorous or as restrictive. And it's a league that's much more decentralized than, for example, the NFL, the NBA, Major League Baseball. And so if you're just looking at a place where if you have enough assets, you can make a difference, put a winning team on the pitch or the field or whatever you're playing, you're much better off there in a much, I would argue, Greg, a much freer market system. I think U.S. sports, whether they're federal laws or they're just league rules, are so highly regulated that unless you can play within those rules and recognize, so the guys from Manchester City, they wanted to come over here and they wanted to win MLS the first year. Well, MLS looked at them and said, no, you can have 3 players outside of the salary limit like every other team in this league. You're not bringing the Man City first team over to MLS and winning the league in your first year as an expansion team. And they said, why? We have plenty of money. We can pay and we can make that happen. And they said, because it's not happening. We're looking to achieve competitive balance here. We don't want the Yankees winning the World Series every year. We don't want, Seattle or whatever team winning the MLS Cup every year. We certainly don't want you guys winning it every year. And so it's a much more restrictive forum. So I would say that this country, even though they're not sports laws, the leagues are so regulated that it really is a, like I said, the league is the SEC on every deal and every litigation. It really is a pretty highly regulated activity.
Just briefly, because I agree with some of what was said, but not a lot of it. In order to have a league, you have to have certain rules, you have to have certain restrictions. There's no question about that. Number of teams, how many people can be on a team, and things that relate to scheduling games and so forth. In terms of players, it seems to me you don't need, I've always believed this, however heretic it may be, I don't believe you need any restrictions. Because if the league and the owners are true partners, they would share revenues in such a way that they would all have the equal ability to get players, and the players that can win teams. It's not all that complicated. And if you have the skill being putting together a winning team, everybody with the same, essentially on the same playing field. The NFL is close because they do share revenues at a much higher degree than the other leagues. And I think that, frankly, there's no need for a salary cap. I get rid of the whole system that I created, and just let the skill of the owners and general managers decide at any given time. One of the things that you go back, and I'm sure Greg knows this, back in the 60s and 70s when the whole idea of free agency was first being discussed, and the constant refrain from the owner's side was it was going to ruin all of professional sports. It was a horrible thing. My God, the whining and moaning, it was incredible. We just loved it. And the reality is that when free agency came into play in all of these different sports, it's made for a huge amount of popularity. And free agency allows lousy teams to become good a lot quicker. You can't get that good in just drafting one player ahead of everybody else. It doesn't work that way. The reality is that, in fact, and Greg will know this, when the first two teams in expansion in the 90s, Carolina and Jacksonville, came in, there was a quirk because we had just started free agency. And the quirk was that, in fact, these two teams could actually sign up all these free agents, and they were able to. And as a result, Jacksonville and Carolina, if you recall, very early on, one of them made it to the Super Bowl in their second year. When poor Houston came in, the NFL decided we're not going to do that anymore, and they got us to agree, which we did. We traded something off because it didn't matter that much to us. They got us to agree that only a limited number, that Houston could only sign a limited number of free agents. So, the reality is that you can create a great team, but in a lot of different ways.
Time's up. My thanks to our four panelists for giving of themselves for this hour and a half. And some of you should go to class, I guess.
Nice meeting you. Enjoyed meeting you.
More?
Absolutely, love that. It was fun. Nice to meet you.